a power of attorney solves 95% of the problems we're trying to solve by adding people on joint accounts and joint property.
Welcome back to Steadyhand's Coffee Break video series, where we share insights to help you, our Canadian clients and friends, navigate your financial future with confidence. In today's video, we dive into the topic of joint ownership of family assets. Now, that's where an account holder, often a parent, adds another person to their account as a joint holder. It can be an investment account or a bank account. And we're fortunate to be joined by estate lawyer Mike Beishuizen, founding principal at West Coast Wills in Vancouver, to help us unpack the good, the bad, and unfortunately, even the ugly when it comes to parents adding their adult children to joint accounts or to property titles. Mike, thanks for joining us today.
Thanks, David.
Well, let's start with the basics. What does it mean to hold an account or property jointly with a child?
It basically means either of them has access to that account or that piece of real estate. Either of them can monitor it or transact upon it. So either one of them can withdraw money from that account or add money to that account.
So, Mike, what are some of the common reasons why you see parents adding their children to their accounts?
Yeah, the most common reason is just to help parents pay for their expenses during their retirement. So, for example, if a parent goes into a care home, they often add a child as a joint owner of their bank account just to help them pay their bills while they're there. Another reason is to avoid probate. And each province has a probate tax, and it ranges from a flat tax in Alberta, $500, to a percentage of the total value of all the assets passing through the will. And that percentage ranges from 1 to 1.7%, depending on which province you are. And so if you can avoid that tax by having assets in joint ownership with your children, that sometimes avoids that tax. More often than not, it doesn't avoid that tax, though. Common misconception. And then the third reason is after the parent dies, if there's a joint account with the child, it helps the child pay for estate expenses such as funeral fees, lawyers' fees, property taxes if they come up, probate taxes, that sort of thing.
Okay, so that all sounds like a good reason why joint ownership would work well. Are there other examples of how joint ownership will actually help to, in fact, simplify the process of leading into and working through an estate?
The only way it simplifies estates normally is if there's a small joint account just to help the child pay for estate expenses right at the start. Keep in mind, most banks freeze the parents' accounts when they receive the death certificate. And they remain frozen until the grant of probate is issued from the court, which takes about 6 months occasionally. So if they have a small joint account to pay for those initial expenses, like the lawyer fees, accountant's fees, funeral expenses, the probate tax, then that makes life a little bit easier on the family. Keep in mind, most banks allow those fees to be paid anyway. The child just brings in the invoice and the bank cuts a bank draft to that child.
It sounds like these joint accounts are a good strategy for avoiding probate in BC and some other provinces. And I suspect we'll get to maybe why that's not necessarily always true in a moment. But are there, beyond a bank account, are there other particular asset types or accounts where joint ownership is appropriate?
Not generally. Just for tax reasons and logistical reasons, it's often not as advisable to have a joint account, except for that very limited situation where there's a joint account just to pay for those initial estate expenses.
Let's move from the good and the appropriate to potentially the bad and the inappropriate. In your experience, what are the misunderstandings and frankly the risks that people need to understand around joint ownership?
Joint ownership is hugely misunderstood by the general public in Canada. The law says that when two spouses own something jointly, so be it a bank account or a piece of real estate, it's deemed to be for survivorship purposes, so the right of survivorship. So if one of those spouses dies, it automatically passes to the other spouse that's surviving. With children, it's different, and this is what's misunderstood by the public. When say the surviving spouse then adds their adult children on title to their bank account or the real estate, the law presumes the opposite. The law presumes that it's just for convenience purposes and it's not for inheritance purposes. So that child, after the parent dies, has to hold that bank account or piece of real estate in trust for the estate and distribute according to the will.
I guess that's a good thing if there's more than one child.
Correct. Sometimes it's a good thing. Sometimes it's not what the parent intended. The intention is the most important. So it is a rebuttable presumption. So if the parent truly wants the child to inherit that piece of real estate or that bank account, they need to write down, dated at the time of transfer, write down that they intend to gift that child the right of survivorship. So the child does inherit. From experience, 99% of the time, no such writing is there, and everyone's wondering, is this for convenience or is it for inheritance? And the law says, in the absence of that writing, it's for convenience only and passes according to the will.
Mike, you mentioned the default case when the courts are looking at the intentionality of these joint accounts is sort of stewardship for the benefit of the estate. But if the intent was actually to avoid probate and have the money go directly to the child, you suggest that there should be a letter specifying that. Tell us a little bit more about that letter. What's in it? Where should it be kept? Who's it lodged with? That sort of stuff.
So if it's a simple, small account, just a simple letter from the parent, dated and signed, dated on the date of transfer, just saying it's for inheritance purposes should do the trick. It's not that big of a deal because it's a small account. If it's a bigger account or a piece of real estate, then you should get the help of a lawyer, just because you want everything T's crossed, dotted, I's dotted, just to do everything properly, just to make sure that it does indeed pass to the child. Especially in the terms of if they're passing that to the child in order to disinherit another child, you want everything to be watertight. And so it should be vetted by a lawyer and prepared by a lawyer. It's called a deed of gift. That's what lawyers prepare in that situation. It should be kept with your will, not stapled to it, but just in the same envelope or the same package with your will, because it's a estate planning document. It should be viewed in the same light at the same time as your will.
Interesting. My father is 97, and last year he was the victim of an online scam. And my brother and I, together with my father, decided it would be appropriate for me to have oversight on his bank accounts. So my father and I went to the bank, and I was added as I can view. Well, actually, I can actually transact as well in his online in his bank account, but I'm not a joint holder. Is that a good practice or is that dumb?
I'm not sure what the bank in that situation did. The best practice, and what I recommend to everyone watching this, is just to have a power of attorney. Simple power of attorney allows the child to do anything that the parent would be able to do with their account for the benefit of that parent. So they can't take money out of the account and use it for themselves or for anyone else, but for the benefit of that parent. So they can pay the parent's bills, they can file the taxes, they can sell their home if needed. That's what a power of attorney does, and it completely skips over joint ownership and all the perils that lie with joint ownership.
Let's move to the ugly. And in your experience, I'm sure you've seen some really ugliness, and this is when the joint account holding backfires. Can you give us some sense of just how bad it can get? What sort of ultimate legal disputes happen? How does it fracture family relationships? And then we can kind of wrap up with what are the best practices going forward.
So there's a lot of downsides to jointly held accounts and jointly held real estate. First is it becomes available to the children's creditors. And so there was this case in BC about 2 years ago, a widow and her only child, seemingly simple estate plan, she put her only child on joint ownership of her home. Several years later, he went bankrupt. He was a real estate developer, went bankrupt. The creditors did what every creditor would do, and they searched the land registry to see if he owned land, and lo and behold, he owned half his mother's home. So they claimed against it, wound up in court, and the judge sided with the creditors because he was half owner of the home. And so luckily, the judge in that case let the mother live out her life in the home, but after it sold, half of it was going to the creditors. Keep in mind, a lot more common situation is that people get divorced. And so an ex-spouse is a creditor, essentially, of the child. So if the mother put her son on the home in 2010, and then the son got divorced in 2025, the spouse probably has a claim to half that home during the meantime. And so that's a huge risk that the mother is taking in that case. The second reason why it's probably a bad idea to add children to a piece of real estate is the principal residence exemption to capital gains tax. Luckily in Canada, our government has given us a big, huge gift, and it's called the principal residence exemption. So when you own a home and you live in it, it's generally called your principal residence. So when you sell that home, even if it's gone up $1 million or $2 million, if you bought it in the 70s and you're in Vancouver in 2025, $2 million capital gain, that's tax-free if you've lived in it and you've owned it the entire time because it's your principal residence. It's called your principal residence exemption. What happens now if in 1990 the parent added their adult child to the title of the home? Essentially, the child has their own home, that's their principal residence, but they've just been added to the mother's home. The mother has just given away half of their principal residence exemption, so it becomes taxable in the child's hands. And as mentioned, if it's in Vancouver, 1990 prices until 2025 prices, it's a huge difference in price, and that could be a $500,000 tax bill sitting in the child's lap when they sell it. So huge consequences for that, adding a child to your principal residence. And then third main reason is, unfortunately, people come into our offices all the time, and the meeting starts off fine, but maybe 10 minutes into the meeting, we get to talking about their children, and the meeting just sort of takes a step back, and the client says, I haven't seen my child in 10 years. This is why I'm here. I want to disinherit them. Obviously, if you've put that child on joint ownership of your home and your bank accounts, it's too late to disinherit because they are half owners of everything.
Are there any really clear, definitive pieces of advice and best practices that you would want to leave our viewers with as they contemplate joint accounts with their children or others?
Yeah, two pieces of advice. If you're already in that situation, seek legal advice as to how to get out of that situation. Because obviously with capital gains tax, The longer you wait, the more tax accrues and the worse off you'll be. Secondly, a power of attorney solves 95% of the problems we're trying to solve by adding people on joint accounts and joint property. There's two types of powers of attorney. One is a bank power of attorney. So it's called a restricted power of attorney. It only lets the child transact on accounts within that financial institution. A much better option is a general power of attorney. And so with a bank power of attorney, people get sort of comfortable with the fact that, hey, I can do anything for mom that is needed, but all of a sudden mom becomes incapacitated and then they have to file a tax return. Well, CRA won't accept a bank power of attorney. It's just for that bank. Or they have to sell the house. The land titles office won't accept the bank power of attorney because it's restricted to that bank. So it's a much better idea to get what's called a general power of attorney. And that lets the child transact on that bank account, pay their bills, file the taxes, renew car insurance, sell the car, renew home insurance, sell the home, mortgage the home. Anything that the parent would be able to do, the child can do on their behalf using a general power of attorney. So that's by far the easiest, simplest, cleanest method to do it rather than a joint account.
I think we've got our next coffee break topic, Mike. So we'd love to have you come back and talk about powers of attorney in general. I'm sure that that'd be very beneficial to everybody. And we hope that everybody watching, that you gain some valuable insight for your own estate planning. If you have any questions or any topics that you'd like us to cover, please drop them in the comments below. And don't forget to like and subscribe to the Steadyhand YouTube channel for more helpful videos. Again, Mike, thank you, and thanks everybody for watching.